First name Michael.
Bond or custody?
Bond.
Okay. Okay, what's the word?
He has two cases, reckless driving and a pistol case out of the same transaction.
Okay.
State has offered him PTI with a bunch of things to dismiss.
We got that off for December 23rd, or I'm sorry,
January 23rd.
January 23rd.
So he signed the contract this morning so he can get started on all of the things. So he just needs time to do defensive driving, decision-making, gun safety class, and then a $100 donation to the food bank.
Michael Washington, come up. So it's 180 days.
I know, that's why I don't.
I'll give you 3 weeks, but if he's not done by then,
But he doesn't have to do community service hours.
Right.
It's just class.
so, you've been given a great offer, right? They're willing to dismiss both your cases. All you have to do are 3 classes. Your case is 182 days old. I'm not giving you much time to get it done. If you don't have the wherewithal to have it done within a couple of weeks, I'm setting your case for trial. Do you understand? Okay, man. All right. Good luck.
Pause right there. This is what they call a sweetheart deal, pre-trial intervention, or PTI. It means if the defendant clears a few basic requirements, the entire case vanishes. No conviction. Sounds simple, just 3 classes and a donation. But here's the catch. Judges have no patience for delays. The warning: don't confuse leniency with the absence of consequences.
A couple weeks.
Judge,
Hi.
approach briefly.
Of course.
How you doing?
How are you?
I had filed a motion to sub on the accused sub out Mike Snyder.
Is it on today?
It's on the docket today.
Okay, I'll
But I
sign it.
think I didn't have the order, and that's been a problem. Slider.
Do we have a motion to sub?
I'm gonna do one now.
Yeah. Just have you talked to Slider yet?
Yes, I've only been knowing him since I was 13. So
The only problem is it's old.
Right, and I know we need to get moving, and I was wondering what happened, because I never could get the information, but I didn't file the order, so that's on me.
Right. Okay, yeah, I'll sign it now. Talk to the state, see where you're at, and then just let me know.
Maybe one reset and going one way or another.
Okay.
I just need to see it.
Val. How are you?
I'm doing well, Judge. Thanks for asking. How are you?
Good.
I'm approaching on Lan Nguyen. Nguyen is the last name, Nguyen.
I see it.
State's been attempting to get in touch with the complaining witness. Been waiting for a while.
You guys set?
This is an underrated hurdle in the justice system: language barriers. A case can't move forward without hearing the complainant's side, and that depends on having the right interpreter. It's not just red tape, it's due process. Now, here's a question. Should courts be required to have on-call interpreters for all common languages in their district? Drop your thoughts below.
Investigator in October.
Yeah, and the issue is we need a Vietnamese interpreter because every person we get in contact with, the last person, they don't speak it. So we're
4 months though,
So we'll try reaching out as soon as we can. Today, we'll try see if we can get in touch with a Vietnamese interpreter, but that's the issue. We can't communicate. Yes, Judge.
At a week, that's it.
Thank you.
All right, thanks.
We waiting on somebody. We waiting on somebody.
I can help you.
I'm with
Okay, so last note we have on this one is that I believe Slider is the mitigation packet on those. So now it's back in October, so do you know if it
What
will
will happen is my father. That's why I never had so I want to see that.
Okay,
I'm sure we'll make them on the same thing.
okay, gotcha. Because it's right. Yeah, because
Look at it, I'll reach out to you.
gotcha, and that's for PTI, if you want to do that. Otherwise, we already have a time cert offer on there. That's what
But he has a PTI.
Well, contingent first do the mitigation packet, let us look at it, and then we'll determine if.
Judge, may we approach?
Tell me.
So he has a PTI offer contingent on the packet.
Well, if
Mitigation.
we'll offer,
Yeah.
we'll put a PTI, once we look at the mitigation packet, we'll determine if we're willing to make an offer of PTI.
Okay.
So how long do you want? What was the last name again?
Hughes. Sure, I'll be attached to the case today, so I can,
He's here, right?
yes, he is.
Lee Hughes, come up.
I went outside and talked to him, so he's standing right there. She's going to get him.
Okay, great.
You okay?
Doing great. Thanks, you.
Seems like everybody has this little nasal deal.
My daughter suffers, man.
Trying to get on the other side.
What up, Mr. Hughes? Your lawyer is trying to work a deal where he's trying to get an intervention agreement for you. You need to turn in what's called a mitigation packet to try to secure that kind of agreement from the state. As with anything in life, you get what you put in. If you put your heart and soul into it, you can achieve damn near anything. But if you put something together, it looks like you did the night before on a bar napkin, don't expect much. He's going to ask stuff for you. If you don't put your heart into it and soul into it, don't expect much. Do you understand?
Yes, sir.
Now, your case is 190 days old. I'm going to give you one last setting. You will not get any more time after this. I will give you 3 weeks, 4 weeks, but after that time, you're done. If you have not completed your side of the bargain, I'm going to set your case for trial. You get no more time. Do you understand?
Yes, sir.
Okay, you got 30 days. That's it. All right, we'll have you see.
You're welcome. Now, before we start.
Yeah, I'm ready.
Mr. Cruz. Amari Cruz, shall I call him up?
Counsel Fleischer. Oh, Elaine?
Yeah.
Nate, top page Nate.
You, Mr. Amari Cruz Serrano. Yes, sir. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On January 30th, 2025, the officer was dispatched to a major crash on West Dallas Street in Harris County, Texas. The officer observed a bumper part of the motor vehicle at the scene where the defendant's vehicle struck a pole. The license plate was attached to the bumper, which came back to a blue Toyota Corolla when ran. A real witness saw the motor vehicle parked on the shoulder of North Freeway, matching.
Did you catch that contradiction? One drink suddenly turned into two, and now the missing bumper is just a coincidence. That's courtroom quicksand. Here's a rule of thumb. If the evidence is literally stuck to your bumper, you might want to rethink your story.
Description given out by the officer on the side of the freeway with the defendant in the driver's seat. The real witness observed the defendant get out of the vehicle to change his tire, and the real witness stayed on scene. The officer observed the defendant kneeling by the front passenger tire, instructed the defendant to step away from the vehicle to come over to him, and observed bloodshot eyes, a strong odor of an alcoholic beverage, and then administered standard field sobriety tests. HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 0 out of 4. The defendant was read the DIC and consented to breath. The results were 0.082 and 0.083. The defendant then stated he was coming from a bar. Was just broken up. He had one drink of Hennessy and Coca-Cola, though he later stated he had 2 drinks, and that his missing damaged bumper happened in the past, and that the bumper was probably at his home.
Okay. Any prior DWIs?
No, Your Honor. And his license is eligible.
Got it. All right, Mr. Cruz Serrano, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. You're going to be randomly tested. If I find that you're consuming alcohol, any kind of illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, Your Honor.
As long as you have a valid Texas driver license and liability insurance, you may continue to drive. But if you don't have one or the other, then you're not allowed to drive. And that is also a condition of your bond. You understand?
Yes, Your Honor.
Now, you have a lawyer. Because you have one, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel, and he will tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, you're not responding to phone calls, text messages, you pick up a new case, you become a danger to my community, I only have one place for you. You understand?
Yes, Your Honor.
Okay. I'll have you sign a receipt of Victoria. We'll have you meet with Fleischer of your bond conditions, and then you're free to go.
Thank you, Your Honor.